I am Wanderley Fernandes. I'm a professor here at the Law School of Fundação Getúlio Vargas. And today we are here to talk with Professor Francisco de Elizalde, the Instituto de Empresas, University de Madrid. And Professor Francisco has a relationship with Fundação Getúlio Vargas through the Law School Global League. There is a group of several law schools around the world, and we work together in different projects. And this week he is here to teach in the Global Law Program of Fundação Getúlio Vargas, in which we have students from other countries and also students from Fundação Getúlio Vargas from different programs. And so, good afternoon, Professor Francisco.
Good afternoon.
We are very honored to have you here. And I would like to hear from you, what is your connection with the moment in Europe, the moment of unification of contract law, and how do you think that this movement of modernization of contract law in Europe could influence other countries, other legal systems like Brazil, for instance?
Great. First thing I want to say that I want to thank FGV for the invitation of being a global law professor. It's been a great experience this week, and it's always glad to work with one of our dearest members of the Law Schools Global League. In respect of your question, the movement for harmonization of European contract law started around already more than 30 years with the idea of having uniform rules for all Europe that could present Europe as a competitor with one set of rules in front of the rest of the world. The process had two different aspects or different effects. One in terms of soft law, proposals, mainly as the principles of European contract law, the draft common frame of reference, proposals that have not been enacted. They are not positive European legislation, but they have had a great influence. First of all, within Europe. For example, they have been influential in the reform of the German Civil Code, in the reform of the French Civil Code, and they are commonly quoted by certain Supreme Courts, for example, the Spanish one. This influence of this soft law experience is starting to exceed the boundaries of Europe. And for example, there is an incipient project in Latin America that is in the phase of elaboration, of drafting, of a principles of Latin American contract law, in which also from Spain we are kind of preparing a criticism and trying to help them to have the best draft as possible. And also in Asia, there are several initiatives, for example, the principles of Asian contract law, etc., that they all mirror this European experience. And on the other side, the hard law, the law that was passed by the European Union, it has had great effect in different countries on the world in respect of the level of consumer contract protection. So I think all in all, the movement for harmonization is still in its way. There's still lots of things to be done, especially it is uncertain what will happen after Brexit. Mm-hmm. But still, it's a process that I think should be followed on. I think it's a process that has had a very positive effect in Europe, and as I told you, it's also exceeding the boundaries, affecting other countries, and the process itself is worth it. Mm-hmm. If you ask me more concretely what the process consists of, so these rules that are being proposed have helped, first of all, to modernize the civil law. The experience of having two main legal traditions, or better, three legal traditions, because you have the Germanic civil law tradition, the French tradition, and also the common law working together has been very beneficial for all of the parties. And it has helped the civil law to get rid of certain concepts that were old-fashioned and not necessarily part of the core of the civil law, and helped thus the legal systems internally and internationally. And also it has helped in the sense, or it has introduced certain concepts in the law of England and Wales as good faith in certain aspects, that has also contributed to the development of other areas of the law. So all in all, if we need to look to the process of harmonization as a whole, not just look to precise what happened with this proposal, if it was enacted or not, but see all the effects that this has had to the moment, and I think the effects are terribly important.
Yep. And what's the influence of the Vienna Convention in this process?
Well, the Vienna Convention, the CISG, has been fundamental. As you know, in the CISG, we had people from and experts from different countries working together, from different legal traditions, and they managed to make one set of rules that reflected different opinions. In certain areas, there was a compromise among them. Some traditions had to leave aside some of the opinions they brought to the meetings and had to accept other ones. It was a compromise. But it was a compromise that was taken 36 years ago, that has been working very well, efficiently, accepted by courts and judicial and arbitral courts worldwide. And the model seems to be good in respect of its rules. And the effect that it has had is that the process of harmonization of European contract law has taken in lots of aspects the CISG as a model. A model, especially of course in respect of sales, all the modernization of the concept of breach, objective breach, the system of remedies, the system of conformity of the goods that are being sold. Lots of notions that were not necessarily correspond to one or the other legal system were incorporated there, were seen as a model of modern contract law, and has served as a mirror for the whole process of harmonization.
Mm-hmm. Yeah. There is another issue that we have discussed this morning, that in Brazil there is sort of some professors, especially in São Paulo, some professors from here, FGV or University of São Paulo, about a certain confusion about how applying the law, as for instance good faith, to commercial contracts, and a certain influence of consumer law in the way that certain decisions are taken. Is the same in Europe, or you think that the judges or arbiters in Europe, they have a more sort of definition about what is supposed to be a consumer principles and entrepreneurial principles?
Well, I think that before answering precisely that question is consumer law has certainly have a say in the evolution or modernization of the law. And we can clearly see this, for example, in the regulation of standard terms. How is it found now in Germany and in France, for example? It has had a certain say in the certain regulations in respect of sales, but things that were not purely consumer aspects. For example, the principle of conformity of the Vienna Convention was then incorporated into the Directive 99/44 of the European Council that has to do with consumer protection. The rule itself was good, notwithstanding the parties. But once the rule is enacted, okay, once we know the level of consumer protection, then in Europe I might say it's quite high, it is clear that those rules should only be applied to consumers. And the B2B or business-to-business commercial contracts stay outside those regulations. Because, of course, the asymmetries or the disbalances between those parties, even though I don't say they do not exist, should not be or are not better underneath the reasoning of those rules. For example, think about freedom of contract, think about vices of consent. The legal background, the legal reasoning for one or the other case is different.
Yep. Well, I think that we had a good moment to talk about this, but I know that Professor Francisco has been very busy, so I think that at least we had this short time. We could continue here for discussing the full day all these interesting issues, but I think that at least for our students it was a good moment to show how you are involved in these issues in Europe. So thank you very much, Professor Francisco.
Thank you very much.
Nice to be
pleasure.
with you.